Thank you very much. I'm really glad to have this opportunity to do this again. I would just like to clarify, it wasn't the Bush administration I investigated. It was what they were saying about children, or about children at this,
Real close.
real close. Am I better? Okay. What they were saying about our nation's children at that time. I decided I needed to find a place that I could go and look and see if they had turned into a completely alien species. So I went to a Seattle middle school, because my question was, if we have these facilities that seem to be turning out faulty products, what in the world is going on in the facility? If they were a factory turning out faulty products, we would be concerned about the factory as opposed to the product. So that is my curiosity. I very much want to see how the world around us contributes to who and what we are. And I must say, my favorite intellectual environment has been the League of Women Voters. I have greatly, greatly enjoyed the kind of curiosity and intellect and caring about the community that I found in the League of Women Voters. So thank you very much for coming to hear me today. Perhaps all of you have read this already. What is the mission of the League of Women Voters? The League of Women Voters is a very active and important national age organization working on many, many different kinds of issues. And one of the things that seemed most important to me as I began watching what was happening after 2010 and the Citizens United decision, the Supreme Court decision, Citizens United versus the FEC, I thought the League would be exactly the place that I would be able to find a way to engage the conversation about that issue. And I was wrong. I found it very difficult to engage with the League on this issue. And only in now 2015 have I been able to learn the reason that it was very difficult to engage the League. This statement comes from the study that they have now introduced to those of you who are members. The Money and Politics study has been discussed this past unit meeting. The next study coming will be discussing amending the Constitution. And the League decided that we do not have the positions necessary for us to engage this issue as it has been presented to the public. So now what we are doing is we have put together a research project analyzing the League's positions in money and politics, and also trying to decide how we will have a position about approaching amending the Constitution. So they stated, we believe that our current campaign finance position does not address the First Amendment issues that the Supreme Court acted on in that decision. I should say most of these slides came from the Massachusetts League of Women Voters, who has also been working very hard to cause the National League to engage it. And this issue of money in the ballot box is certainly something that has become very much a part of our discussion today. But it isn't a new discussion. And it is interesting to note that during this time, soon after, let's see if I can go back. During this time, when corporations were so very powerful, soon after the end of the Civil War, soon after the 14th and 15th Amendments, they suddenly gained the status of being considered persons. And I don't know if you've heard in the arguments about whether, about this person's status of corporation. That relates to their First Amendment rights, right down to the fact that Hobby Lobby's owners can decide whether or not women can have reproductive health services paid for by their health insurance from the corporation. But it happened in 1886. It wasn't that the court actually declared that the corporations have are persons. Instead, it was the court clerk that wrote into the transcript of this particular hearing, or this particular case, which was the Santa Clara County versus the Southern Pacific Railroad, over whether or not the Southern Pacific Railroad should have to pay taxes in Santa Clara County.
It's okay.
Beginning with that, we have been working hard.
Janet, try the podium and see if that works more easily for you.
Is this?
Oh, there we go.
So this list describes what it has been like since that time with various kinds of legislation that have attempted to deal with the periodic swings of corruption that have been a part of long-term American history. So beginning with the Tillman Act in 1907 and the Federal Corrupt Practices Act, public citizens and the legislatures began to intervene. However, with the end of World War II and the kinds of arguments that happened during that time, unions began to be one of the most important organizing units in the country, and corporations again began to want to be not so. Corporations were very anxious to be able to make their own decisions for themselves, and they began to try to intervene in how politically active unions were, which is what the Taft-Hartley Act accomplished. By the time of the 1960s, these issues of public protest and legislation began to be very active in the community, and the response to that was the Great Society legislation, along with the Voting Rights Act and the Federal Communications Act. But there were other things that were happening at the same time, and Lewis Powell, who was at that time a very important lawyer a national lawyer, wrote a letter to the National Chamber of Commerce in which he stated his concern about what was going on dealing with the various kinds of efforts of other groups in society to assert rights and control. This is what he wrote to the president of the chair of the Chamber of Commerce. No thoughtful person can question that the American economic system is under broad attack. What now concerns us is quite new in the history of America. We are not dealing with sporadic or isolated attacks from a relatively few extremists, or even from the minority socialist cadre. Rather, the assault is on the entire enterprise system. It is broadly based and consistently pursued, and it is gaining momentum and converts. Mr. Powell identified those people that he thought were the converts. The most disquieting voices joining the chorus of criticism come from perfectly respectable elements of society, from college campuses, the pulpit, the media, the intellectual and literary journals, the arts and sciences, and from politicians. And with this statement, he organized a 25-page article in which he outlined a very, very specific plan using the United States Chamber of Commerce to rally the money and the leaders of corporate agencies in the country to do their very best to counter step by step each of these things that the public uprising and the efforts to build a more representative government that had been passed in the 1960s and into the 1970s. With the passage of the Voting Rights Act, with the passage of, just a minute, I need to go back. At the time that Mr. Powell wrote this, Richard Nixon was President of the United States. Soon after he wrote this, Richard Nixon appointed him to be a Supreme Court Justice. Soon after Mr. Nixon appointed him to be a Supreme Court Justice, Mr. Nixon won a landslide election in 1972. Soon after that, the Watergate scandal erupted. So Mr. Nixon was one of the first politicians to be confronted by the attempts to set up campaign finance regulation. The 1971 FEC law, however, didn't come with penalties. So the people who were prosecuted during the Watergate investigation were prosecuted for things like robbery, not for the misuse of political campaign funds. By 1976, after the passage of a very much stronger Federal Election Campaign Reform Act, various Republican agencies began to bring suit in the Supreme Court. And in Buckley versus Vallejo, the limits on campaign contributions to their own campaign was overturned. The court ruled in this first decision that it was a violation of a candidate's First Amendment rights to make any limit on how much that person can spend on his or her own election. In the First National Bank versus Boston, the ban on spending to influence ballot referendums was overturned. It was determined that it violated corporations' free speech rights to not be allowed to make campaign contributions about subjects that were of great interest to them. And in this decision, the court ruled that it is unreasonable to violate the idea. This was about public financing, the kind of public financing in which a candidate agrees to limit the financing he will accept from the public in return for being able to receive donations from a public fund. And the fund was organized so that if a wealthy candidate found ways to have more money than the candidate using the public fund had, that they would increase the amount of that fund. That was called leveling the playing field. The court ruled it is not fair to the person providing his own wealth that the rest of us could contribute in that kind of way. By doing that, what it says is and the ruling said, the candidate who is financing himself is very unlikely to want to continue financing himself, because what he's actually doing, if this other candidate is actually getting more money, is he's actually paying that other candidate to get more money. So why should he do that? Why should he use his own money to do that? And that will limit our opportunity to have the best parts of the argument. However, there was still action and protection from the Supreme Court. The Austin versus Michigan case in the Supreme Court confronted the issues of the kind of corporate corruption that still was important and of concern, and declared that aggregations of immense wealth, which had to do with the Michigan Chamber of Commerce. The Michigan Chamber of Commerce said, we are a nonprofit, therefore we should have a different status than a for-profit corporation does. And the court ruled that the Chamber of Commerce receives almost all of its funding from corporations, so that to say, and that most of the lobbying that they do is greatly to the benefit of those organizations that contribute to them. And so still with Austin versus Michigan in 1990, the court ruled that it was reasonable to limit the use of general treasury funds for the Chamber of Commerce, as it was still in that time reasonable to limit the funding from the general treasury of corporations. In 2005, President George Bush appointed John Roberts to be Chief Justice upon the death of William Rehnquist. This statement comes from the League of Women Voters discussion in Money and Politics. It's hard for us as members of the League to talk about issues in terms of political parties. We try to be as even-handed as we can be. We do not campaign for particular candidates. But as we have been trying to deal with these issues of representation, it is very hard to say that, or to not say, that on the one side we have great effort to increase the opportunities for representative government, and on the other side we have many efforts to make sure that representative government, that those representing us in government are corporately appropriate candidates. This is the decision that clarified it all. The Citizens United decision versus the FEC. All speakers use money amassed in the economic marketplace to fund their speech. And the First Amendment protects the resulting speech. It's worth taking a step back and thinking about that, to say all speakers use money amassed from the economic marketplace, because this is one of the issues that the League is trying to confront. We can say that our position says we will do everything we can to support representative government. We have not thought in the terms of saying that it's money itself that is the most important tool in that process of government. Whether or not you agree with that, and that kind of is what the issue of the consensus questions that came with our Money and Politics study are trying to cause us to be able to express better. Do our feelings about what free speech means, does the grounding of our positions in free speech, is it negated when the issue is money.
Good point.
The censorship we now confront is vast in its reach. The government has muffled the voices that best represent the most significant segments of the economy. Now, I've been working on this issue since about 2011, which means that, and I have read and reread the decision many times, and it was only in the very recent past that this leaped out at me. I mean, and what he actually says in this opinion, that those voices who were held in check by limits on how much money they could spend represent the most significant segments of the economy. Now, if you go back to Powell's statement, the thing that he articulates really overtly, I really recommend that you read it if you possibly can, is that our values are completely coordinated around what is good for our free enterprise system. And over the years, I've been trying to find in the League's positions the statement that we must be certain that none of these positions interfere with the corporate opportunity to profit. It's not there in our positions. It's not stated there. And yet we still find ourselves asking, where do our positions fit with something like the minimum wage? Because we don't overtly have a position advocating for the minimum wage, we still find ourselves having a conversation about, but if we raise the minimum wage, that will mean that employers have to pay their employees more money, and that will make it more difficult for employers to make a profit. So these are issues that we take so for granted that only when you see something as blatant as this did it leap out to me. This court now concludes that independent expenditures, including those made by corporations, do not give rise to corruption or the appearance of corruption. The reason that this is such an important statement, well, take a step back. Think about what you think about corruption. This issue of corruption was one of the major reasons that the Supreme Court in 1990 upheld the conditions in Austin versus the Michigan Chamber of Commerce. At that time, the court stated, we are concerned about how too much money given to political campaigns can cause either corruption or the appearance of corruption, and cause people, citizens, to consider that perhaps their government isn't as trustworthy as they want it to be. The appearance of corruption in the Austin case was almost more important than actual corruption. By 2010, that Supreme Court declared that it is not possible to be, not necessary to be concerned about corruption. Justice Stevens did dissent. Before Citizens United, the court did not rest our holding on a narrow notion of quid pro quo corruption. Instead, we relied on the governmental interest in combating the unique forms of corruption threatened by corporations, as recognized in Austin's anti-distortion rationale. quid pro quo. This is what now the court rules is actually illegal. The actual exchange for money from a campaign contributor on the floor of the Senate into the hand of the legislator, who then does vote in the way the man has asked him to do. That is the limit of corruption today. The other thing that I began to realize as I reread and read the 2010 decision, as well as all of those that have followed, is that the thing that was freed, as they were saying, we cannot have limits on campaign finance, was the opportunity for expenditure. That's the word that is used. It is not, it is a violation of free speech to limit how much any person or corporation can spend on an election. And this particular cartoon just sort of proves it completely. I think it says it wonderfully, because what is happening is the money is just whooshing out. The voter is sort of just overwhelmed by it. It doesn't have a destination. You know, in this, where does the money go? Well, it gets to be more and more. This is a chart that shows how much having the freedom to spend as much as you want has increased the cost of elections. And this is a chart that expresses who has chosen to want to spend so much money, which is a flabbergasting idea that these people want to spend this kind of money. These are the people, and this was from 2014. We're not talking about now. We're talking about the people that made those that wanted to spend at that time 47 elite givers gave more than 43% of the population. This is an interesting graph because it states the difference that changing the Supreme Court law has been to allow the various organizations to contribute. The trade associations, and it's the trade associations that the Taft-Hartley Act was designed to limit. Unions, no wait, that's, yeah, but the 501c4 nonprofits, is that a phrase that you're familiar with, the 501c4 profits? The League of Women Voters is both a 501c3 and a 501c4 corporation. The 501c3 part of our, well, we're two separate corporations, and the 501c3 is the reason that we can say your donations to the League are tax deductible. The 501c4 is how we operate the agency that we run. We use funds from the 501c3, but because we are then operating in a 501c4, we can do the kind of public forums, voter education, that kind of public service that is a major part of our reason for being. So for many years, that was something we are really hypersensitive about, the difference between our 501c3 and 501c4 operations. Because if you exceed the amount of lobbying that you do in your 501c4, the IRS can audit you, declare that you have violated your 501c3 charter and declare you are no longer a 501c3, which means that you owe all of the back taxes that you did not have to pay as a 501c3. The IRS has done that. They did it during the Reagan administration to a Planned Parenthood organization in Alaska. They audited it. They determined that they had violated their 501c3 charter, and all of the board members of that chapter of Planned Parenthood were required to pay all of the back taxes. So when government wants to use the tools it has, it can and does. Now we have 501c4s that are the conduit for almost all of that money that was seen in that cartoon. That money is being blown into these places. Now, this is not something I'm going to describe at all, except to say what it is, because it's a chart that actually has traced the flow of the money that goes from individual wealthy donors who are anonymous, because the 501c4 also grants that to them. So a business can be donating to something that its customers might think was really quite against their interest, but the business, don't need to find that out because they are donating in secret. And then it circulates throughout the country through the various super PACs that are then formed and to collect and process the money, and the advertising that you get to have coming for particular issues. I think that, yes?
Could you clarify that contributions to the League Education Fund are tax deductible, but contributions to our regular dues are not tax deductible? And also explain the difference between 403B and 4 in terms of announcing the names of the givers.
Okay, I'll begin with the names of the givers, because I think that it's a very, very interesting part of our history. During the Civil Rights Movement, from the eruption into the 40s, 50s, and 60s of the Civil Rights Movement, the NAACP was a 501c3 organization. And sheriffs in local communities demanded the lists of their donors. The NAACP took their case to the Supreme Court, stating that this was threatening the lives of the people who chose to donate to the NAACP. And the court agreed. The court agreed that having townspeople and sheriffs have access to the names of people in the community that wanted to donate to the NAACP really was dangerous. That is now court principle. Therefore, the 501c4 corporations or organizations claim that fear, that right to fear, that they too could be persecuted for their opinion. And if you can remember, was it here in Washington or was it only in California at the time of the marriage equality campaign? And there was a very significant campaign organized to defend the right to one man and one woman marriage. Those people demanded that they also not have their names known. And they used the claim that they could be persecuted. And they won their case. So that's one of the most important aspects of being able to be the 501c4 corporation. Prior to the 2010 decision, there was another category for the processing of campaign finance money. And now I'm not able to, it was still one of the 501Cs, but it was like Q. I use that because I can't for sure come up with the right category for it. But they were able to, they had the kind of tax protection that they wanted in those in that kind of filing. What they didn't have was anonymity. So one of the most important things that the League, for instance, advocates for is donor disclosure. There should be disclosure of who is giving money to whom, as a part of our ability to make decisions about who we want to represent us. However, that's something that now the IRS is not willing to take on. That's what was happening in around 2012 when the Tea Party was building its structure and claiming that the IRS was persecuting them because they were asking them to fill out the forms, which the League has been so dedicatedly filling out all of these years. To those people stated that that was a violation of their freedom, and the man who is the head of Citizens United wrote a letter to them all saying, either you stop or there will be a Citizens United versus the IRS. And so far that hasn't happened. Instead the IRS has backed off. Now the League, in its 501c3, we call that its education committee. We are not committee. The education 501c3. When you make a donation, you are donating to the education fund. The education fund does provide money to the operation of the 501c4. Your dues are not tax deductible. Your dues go to the direct operation of the National League of Women Voters, the State League of Women Voters, and to a very small extent to our local Seattle League of Women Voters. That's one of the reasons we are so desperately always working so hard to come up with a brilliant way to attract many, many people who want to come to our fundraising events and provide us a great deal of money. So feel free. Next time, as soon as you hear of one of our fundraising events, know this is a wonderful opportunity for a tax-deductible donation to the education fund of the Seattle-King County League of Women Voters. Is that more questions on that subject? Thank you, Jean. But now this chart is an analysis of where money came in and then where it went for a particular issue that really was interesting because it was sort of coinciding with the IRS issue. A candidate in Texas managed to organize payday loan agencies all across the country to donate to his campaign in one state so that he could influence campaigns in other states. And so the money was almost impossible to figure out where it was coming from. The New York Times did this analysis. They found, they managed to trace it. And along about the time that this was published, that particular candidate stopped being a candidate, and they took on the IRS. This is the next step of the Citizens United progress. The title that I gave, the superhighway, we got to the superhighway after Citizens United. Government regulation may not target the general gratitude a candidate may feel toward those who support him or his allies, or the political access that such support may afford. Now, Mr. McCutcheon wanted to donate, he wanted to expenditure, which is the word they use, not donations, they're called expenditures. He wanted to give an unlimited amount of, he wanted to decide, I guess we shouldn't say unlimited, he wanted to decide how much money he wanted to give to candidates in many different states. And there are states that have limits to how much you can give a candidate, and the Supreme Court ruled that that was a violation of his right to expenditure. So, and the idea that once that expenditure has gone out, you didn't see it landing on a candidate. You saw it overwhelming a voter, but you didn't see it landing on a candidate. That the candidates certainly do know who has been giving them the money, but the rest of us probably are being protected from that information. Now there are no limits to the total amount of money an individual may donate in an election season. And this says, no, Toto, I don't think we're in a democracy anymore. And that's really one of my great concerns. How do we protect representative government during this kind of a challenge? Testing theories of American politics, elites, interest groups, and average citizens. Contrary to what decades of political science research might lead you to believe, ordinary citizens have virtually no influence over what their government does in the United States. This is a quotation from our Money and Politics study. Economic elites and interest groups, especially those representing business, have a substantial degree of influence. Government policy making over the last few decades reflects the preferences of those groups, of economic elites and organized interests. And I would say it isn't just over the last few decades. I think that one of the things that's just really important for us to remember is that this is an ongoing contest. This isn't something that began even in the 1980s. This is something, as I said, showing that first cartoon of the bosses hovering over the legislature in the 1880s and 90s, the Gilded Age and the railroad barons and those things. People who care about representative government have been fighting since before the American Revolution. But here it is, overlooking all of what we do. These are things that have been done, can be done, must continue to be being done in terms of how to control this issue. The legislative change, those legislative issues that happened in the 60s and the 70s, the McCain-Feingold Act, which was instituted in the the late 1990s, after the savings and loan scandal. All of these, there has been a continuous attempt to say, after a scandal, we must do something to intervene. Regulatory change, that's what the Federal Elections Commission tries to do. And constitutional change. And this is something that has been a part of this conversation in the last 5 years, but which the League has chosen, which the League has stated that we do not have a position that allows us to enter into the discussion of constitutional change. What government can do is legislative action, repair and destroy, and now these are just things that are in the active pipeline. These are the kinds of things that the League has been working on since 2010, since before 2010 and continuing after 2010. Repair and restore the Voting Rights Act. Do you remember that the Supreme Court deemed it no longer relevant? That the one provision in the Voting Rights Act that required particular states to report before they made a voting rights change. Now it is the obligation of those in the state who feel the change to prove that it actually harmed them. So the voting rights change in Alabama, they decided that you have to have a picture ID, which you can get from the motor vehicle license place. And in all of the counties with majority black population, they've now closed those DMV offices. Now it's up to those people to prove that they are being harmed. It is no longer a part of the statute that said that the state needs to prove that that doesn't harm. Modernize elections. We've been working on this for quite some time, still concerned about what all of these voting equipment issues are. Pass federal and state corporate charter law standards. One of the most interesting things about corporations is that they are all chartered by states. They are not federally chartered. They pick their state, the one that has the least regulation, and states, any state does have the opportunity to rewrite their own charter standards to rein in some of the issues that they are exploiting right now. Pass the Anti-Corruption Act. Establish viable public campaign funding system. Now, as I'm reading these things, think about whether you know that these are being tried. Think about where these things fit in the frame that the Supreme Court has now laid out for how individual regulatory action can intervene in campaign funding legislation. Donor disclosure of all contributions and expenditures. Washington State has the most powerful public disclosure law in the country. Washington State has the most powerful public disclosure law and one of the very best redistricting systems. The League of Women Voters had a great deal to do with our redistricting system, and it's not perfect, but it stands out and is a shining example. When we go to conventions, League of Women Voters know things like that, and so we get special credit for our wonderful redistricting process. But the public disclosure law is at risk. In the GMO campaign, the Public Disclosure Commission declared that they had violated the opposition to the GMO, had violated the Public Disclosure Act by not disclosing their donors. And when they did, it was visible to see that 6 people from the state of Washington had donated about $100,000 to the campaign. All of the rest of the money came from grocery association corporations, along with major agricultural corporations. So the Public Disclosure Commission provided that information. They still defeated the legislation, but now those organizations are suing the Washington State Attorney General, declaring that that violated their rights, their privacy rights. So those associations as persons now have privacy rights. Prohibit members of Congress from fundraising from interests they most directly regulate. The Supreme Court has ruled that that's simply perfectly fine. Who else would want to give you money? Eliminate pay-to-play opportunities. I'm waiting for some of these expendituring people to decide that they've expenditured enough. So eliminate pay-to-play, that can be quite expensive for some people. Require longer waiting periods between public service and work as a lobbyist. The Empowering Citizens Act and individual candidate super PACs. Repair presidential public financing system. Create similar financing systems for congressional races. Strengthen rules prohibiting coordination between outside spending groups and candidates. We do have an election in the very near future that has an initiative that is trying to do something like this in the city of Seattle, the I-122. The League has endorsed that measure, and Jean Carlson is a very proud sponsor. She can answer your questions much better than I. Government by the People Act provides $25 My Voice tax credit to empower everyday Americans to participate in campaigns. Establishes Freedom from Influence Matching Fund to match small group donations. Provides candidates with additional resources to maintain a level playing field throughout the campaign. Again, these are things that have been ruled unconstitutional. Now we come to our next question that will be what the League is discussing in November. In November, the packet of information will be about the process to amend the Constitution. Their goal is to have consensus from all of the leagues across the country about whether and how we can write a position that will deal with all of the good reasons to consider amending the Constitution. At the same time, avoiding the recognized risks that are a part of amending the Constitution. So these are the criteria that the League has set up. This will be in your packet of information for the November unit meetings. Does the public policy objective address matters of such acute and abiding importance that the fundamental charter of our nation must be changed? Will the amendment as written be effective in achieving that policy objective? Will the amendment make our political system more democratic and/or protect individual rights? And I'm sorry about that. I don't know what to do about that. So, what government can do: regulatory action, enforce and expand FCC disclosure requirements, redefine 501c4 rules, replace FEC with an independent, the Federal Election Commission is a body appointed by the president, and it is evenly divided between Republicans and Democrats. Replace the FEC with an independent, nonpartisan agency with enforcement teeth. It's interesting to think that in spite of what I just said, it is the FEC that has been the defendant in all of these cases that the Supreme Court has heard. The reason the FEC is the defendant is because they have acted in the particular case. In Citizens United, the FEC determined that what the Citizens United organization, that the anti-Hillary movie that they had produced prior to the 2008 election to be released as the primary elections began. The regulation was it could not be, that kind of advertising cannot be done within a very specifically limited time frame prior to an election. They wanted it to be done during the campaign, as close to the time of the decision-making as possible. The Supreme Court ruled that that's the most important time. That is when people are paying attention. So to say that Citizens United couldn't show their most important attack ads right before an election violated their free speech. But it was the FEC that said, no, you cannot do that. So the evenly balanced Federal Election Commission did act in those cases. Regulate corporate political campaigning through the Securities and Exchange Commission. This can be done right now. The Securities and Exchange Commission can require special kinds of reporting to stockholders, shareholders, about the kinds of corporate donations that are made. And then shareholders could say yes or no. This is how I'd like you to expenditure my money. We've been at this for quite some time. We must remember how hard we worked to be able to earn our own right to vote. And it's interesting to know that one of the most progressive things that happened in the 20th century was that women were given the right to vote. It's very important to notice that it could not have happened without men saying, we want women to vote. Because of course women did not have the say in saying we should get to vote. And those men who wanted women to vote understood the power of those fat cats sitting above the ledges in the legislature. They understood they needed more people on their side. The men who voted to have women join them in the fight knew that we would be important allies to them. The last thing I want to say about Citizens United is that it brought it all into relief. These things had been going on since the Powell memo. All of these court cases that I have described were going on prior to 2010. What the Supreme Court did in 2010 was bring it all into public view, to say that there is no such thing as corruption or the fear or the impression of corruption in terms of if it's being danger to representative government. That happened finally in 2010, but they worked very hard and diligently to get there. And we need to work really hard and diligently to be able to interact and counteract it. So, thank you very much. Questions?
Would you like to take some questions?
Yes, be happy to take some
We're getting
questions.
some mics going here. I have a question to start off with. Explain, pay. Use the mic. Explain the difference between what it means to say pay to play and examples of this. You may repeat the question.
I heard the pay to play and examples of this. Okay. Well, pay to play is a pretty... Pay to play could be called extortion. Pay to play is the overt expectation that you will have already donated in order to get the reception from me that you would like to have. The example that I have of it is when Tom DeLay was the majority leader of the House of Representatives, and they set up a very, very powerful lobbying organization on K Street in Washington, D.C. And they announced to corporations that not only did they expect that they would make sizable corporations to the Republican Party, they would notice if they made donations to the Democratic Party. Also, did you hear that Pam Roach, in a hearing, she's the chair of a committee in the Senate, the Grocers Association in Washington State was campaigning to limit petition gathering on their premises. That was 2 years ago, or maybe just last year. At any rate, and I was there when she did it, she addressed one of the people that had come to testify, who is a grocery store owner in the state of Washington. And she said to him, "Do you know what that your association donated to my opponent? You are here in front of me. Your association voted for my opponent, and she lost." And that's all. I mean, and then the man sat there and and looked dumbfounded. That made significant public attention, and Pam Roach was reprimanded for that, because you're not supposed to do that out loud. So that's pay to play. Any other questions? Well, thank you very much for listening to me. I hope that you're curious about all of this, and that, oh, Jean.
Jean has an announcement. When you finish.
I knew this was somewhere. Can you fill us in a little bit about just basic things like what is the league doing to, you give some titles of things that they're doing maybe, but what should we be doing or looking for just as citizens?
Well, all of those things that were listed, and I can go back to them if you want, the various legislative processes to return legislative priorities to representative government. That's what the League has been working on all of this time since 2010. The League has provided amicus brief testimony in each of these court cases. The League works very diligently to in the voter protection areas where these states are making it very difficult for their voters to register. So the League has put extra effort into those states. It's not so easy to see what they do in our state because we are not yet in that kind of a situation. We do have the public disclosure laws. We do have an adequate method of redistricting. We're not gerrymandered like many, many states are. Yes?
Would you take that further and talk about the interconnection between redistricting and campaign finance reform or legislative reform of any kind? Because you noted that this initiative about citizens' voice arose in 2010. It was not incidental that that was a redistricting date, and we are facing another one. The League here has done somewhat of a study in redistricting, and I believe we're going to have an update on it. But the connection is not incidental. The reason you are having these swings and these extremes in things like campaign finance reform is because of the extent of gerrymandering that has taken place since right after the 2010 election. And we can foretell that that will happen again in 2016. So the two actions are very closely related to each other and impact each other.
The reason that the Republican Congress, the reason that there are so many Republican legislators is because of redistricting in those states where it is controlled by the political party in power. In the state of Washington, we have a system in which both parties are represented on the committee, and there is then a fifth person on the committee who is an overseer, kind of organizer, moderator person. But what it means that in the state of Washington, there is still an ethic in the redistricting process that incumbents should not be harmed in a redistricting process. In other states, because what the requirement is, you have to have so many people in a district. The census every 10 years determines the population of a state, and then the state is allocated a certain number of districts, and then the state legislature is given the opportunity to organize all of those patterns of people into their particular legislative district. And gerrymandering is when the state legislature does it very significantly to benefit certain candidates and to benefit to benefit
The party.
the party, but and also to benefit, it has been a great benefit to white people and wealthier people in many of those states that have large minority populations. So come the process happens every 10 years. Unfortunately, well, fortunately, Florida is in a state right now in which their redistricting, their gerrymandering has been disallowed. It has been determined to be so blatant that they've been told now to go back and redo it. But except for instances like that, we're not going to change the Washington state districts until after the 2020 census. It's in these states that the legislatures are making efforts in the present to do that, and until they're stopped, and the league, the league is doing a third study that we will be receiving probably in the spring that looks at redistricting across the country. The comments that I've gotten about it is that because Washington is such a representative state in terms of how well we have done our redistricting, that they're not concerned about us. They are concerned about many, many other states, and it is something that is done, the law says it is for the state to do the redistricting. There is no federal system of redistricting. Some kind of legislation, some kind of federal legislation to cause national redistricting would be interesting, but since we have a Congress that's organized by gerrymandering, it's not likely to happen. Did that do it?
The remaining will come in the study, but we were a partner in initiating a relook at redistricting across the nation, knowing what the impact has been and can be in the future. And it's not just campaign finance reform, it's the right to vote, individual representation, which is being taken away from minorities and less affluent districts through redistricting. They just redistrict them out. So
I would say it isn't just minorities who
No,
have.
I know that, but it's significant. And the targets are already identified for the coming election, because the Republicans were very successful in the last election in bringing, I think, 11 new senators or representatives into their ranks. And they are systematic, were smart. They systematically identified, I think, 26 swing districts across the nation.
We're having microphone problems.
Phyllis.
Anyway, it was a concerted effort, and you have to ask yourself, were the Democrats asleep? The same swing districts were available to both parties, but the Republicans had this concerted drive and successful one to swing the majority in Congress.
I don't know if the Democrats were asleep, but something that I do know is that we are a very polite group of people. I have been asking myself for the last 30 years why it is so easy to do things that are overtly harmful, while it is so difficult to cause people to act against that harm. And it's interesting to think about the people who, I mean, there's an article in the news, in the Seattle Times this morning, talking about, it's a Jerry Large article, talking about a man who has dedicated a significant effort to resurrect the crime of the murder of a man who was organizing, who was a leader in the NAACP in a southern town, and who was murdered in, what was it, in the 1940s. I mean, it was a time more distant. But we need to remember that people have been fighting for representative government since the time of the Constitution. And the Constitution was not written by people who were interested in representative government. They wanted to be represented, and they didn't feel themselves represented with the British administration. But from the time that they gave men, white men with property, the right to vote, the rest of us who were not men, white, property owners, and I suppose it was the men who were not property owners won the right to vote well before anyone else did. Then women were given the right to vote by those men who were not property owners. But it took another, 50, 75, 80 years before those men who were not property owners, but gave women the right to vote, and people died and are still dying because minority people are not given the space that representative government means. So we need to be energized. We need to be something other than polite. And I have to say, this is very much my editorial comment. This is me, having struggled for 5 years to cause the National League of Women Voters to confront Citizens United. This has been a hard process. In 2011, there were about 15 or 20 of us at the state convention that formed a committee to study the impact of Citizens United on the state of Washington. Our goal for that was that we would go to the 2012 National Convention and we would come home with plans of attack for how we could have an intellectual engagement with whatever this process is. We were told at that convention we may not talk about Citizens United because of the issue of amending the Constitution. We never figured out why we couldn't talk about it. I mean, what the issue with amending the Constitution was. There were people in the state of Washington and many other places that were saying, we have to amend the Constitution. Let's talk about amending the Constitution. Let's come up with language that could possibly make a difference about this. But members of the League of Women Voters did not have national permission to say, this is what the League thinks about this. We are a very polite organization. Finally, at the 2014 convention, the studies were authorized. The study into money in politics, the study into the process of amending the Constitution, and what redistricting and an analysis of redistricting in the country. Those are the three things that came from the efforts. And I have to say, the Massachusetts League has been leading the way since 2010. And with their intellectual clout, they have produced, they are the ones that provided most of the documents in this PowerPoint presentation. So please join us in the consensus questions. Please write comments for those consensus questions. They all will be read. The way the League does things is they tally the actual consensus boxes. They collect how many, put an X in each box. But they do read the comments. And I think informing them that we could have done this in 2012 would be good, actually. But that's just my private opinion. Thank you all for coming.
Thank you. Meeting, because that's just a couple of weeks away. You will get in the voter what the actual questions are, and this time it is considerably easier because when you have a yes, no, and undecided sort of question, they give you an example of each one. If you're thinking this way, say agree. If you're thinking that way, say disagree, which will help us to clarify where we are. Okay, it's called Constitutional Amendment Study Guide, and that's where you'll find the actual questions. Now, there is another very large sheaf of papers. Mind you, this is one side of the page. It's called Great and Extraordinary Occasions. I am not positive that in its entirety it is going to be in your voter. I know the whole thing isn't, but the important parts of it start on what would be page 16 of the PDF document. And if you are not able to look at that on your computer, let me know, or the League office, because it's too much to print in the voter. So it will be as an attachment to the message that went out this last week, just 2 or 3 days ago actually. Look back in your received mail, and you will find a connection to the entire thing that you can read on your computer or you can print out. But if you're not able to get a copy of that, let me know, because that will be the important extra knowledge you will gain in order to answer and comment on your questions. Yes, Ann?
Is this working? Any of these?
If it's red on the bottom.
At the next regular meeting, you will get a summary of how we did on the first round questionnaire from the last time, so that you'll have a good feeling for how the group went. I'll get that summary at the next meeting.
And thanks to Ann for doing the tallying of all the reports that were turned in. And I think, Janet, you have convinced us of the importance of our answers and our comments. Thank you.
I would just like to say one other thing. In terms of thinking about amending the Constitution, I think it is fair to say, is this a tool of representative government? Because I think that it doesn't ask that question and it doesn't state it overtly, but there's a lot of concern about how important it is to be careful. And I don't think we need to be told that. I'm surprised at how concerned the National League is that we might not be careful. So that's another editorial comment of having tried to have a conversation about this. So thank you all.
Good.